May it please the court? My name is Michele and I, along with my partner Trivia Sumter, are here today representing Jack Shepard, Kate Austin, Saeed Jarrah, James Ford, Jinsu Kwan, and Sun Kwan, the respondents in this case. Jack Shepard, Kate Austin, Saeed Jarrah, James Ford, Jinsu Kwan, and Sun Kwan respectfully ask this court to affirm the appellate court's decision for two reasons. First, Your Honors, as stated in the case of Rainier versus Union Carbide Court, although my clients are not yet sick, affirming the appellate court's decision would afford my clients legal remedy and recompense should they later develop a truly debilitating disease. Allowing this suit to proceed will provide the justice that they seek for my clients who might in fact later come down with the very diseases they so rightly fear.
Well, Counselor, you talk about how they could later come down with that, and no one's arguing that that's not a possibility, but if they don't have any manifestation of the disease, if they don't know the extent to whether or not, or to the extent of the disease, why should we allow the claim now, and why shouldn't they just file it later on if and when they do get sick? Wouldn't it make more sense to know the extent of your disease and the presence before you recover for it?
No, sir. Also in Rainier versus Union Carbide, there's a quote. But even though a person with HIV does not have clinical disease, they are clearly in diseased state. That being said, there are diseases out there that you could walk around with not necessarily showing any symptoms, but you have the disease. So to wait for the disease, and oftentimes a lot of the diseases, the doctor will say if you came in earlier, we could have caught it. But if there were no tangible symptoms, how did they know to come in? In this case, we know that there's an issue.
Counsel, couldn't that be, though, you follow that line of reasoning to like listen, endless claims, if we're concerned about, you say, you know, something might lead to, I'm sorry, lost my train of thought there.
Well, I understood what you were trying to say. So yeah, endless claims, endless claims. However, in this instance, we know that their property was on radioactive, tainted land, and that they were exposed well beyond the 2 months that they talk about in the case. So we know and even though the chemical eco is not as well known, it's not even on the periodic chart as of this session, we know when we hear radioactive, and there's another word, but when we hear radioactive, we don't think anything good. So by historically, because it can be a danger, you know, to the human body, and we know that they've been exposed for a number of years, we know that something's going to happen. It is going to manifest itself.
Well, we don't quite know that. The statement from the plaintiff's physician says they're in perfect health, and then the sheriff physician said that they could suffer from damage, that this effect could affect them in 10 to 30 years. I mean, there is no certainty here, though.
So in the case of Resolent Products, liability, and litigation, it says here, Dr. Wilson's report, were it admissible, would present a finding that every person who took Resolent and showed any reduction in blood sugar levels has a documented, confirmed, scientifically proved cellular injury because the drug's mechanism of lowering blood sugar is mitochondrial damage. In consequence, assuming that the experts' reports would be admissible, plaintiffs have raised an issue of fact that they each have suffered a mitochondrial injury. Now go on. So first, Your Honor, as stated in the case of Rainier versus Union Carbide Court, although my clients are not yet sick, affirming the appellate court's decision would afford my clients legal remedy and recompense should they later develop a truly debilitating disease. Allowing this suit to proceed would provide the justice that they seek for my clients who might in fact later come down with the very diseases they so rightly fear.
What compensation are your clients looking for? Are they looking for a hard number for money, for payment? Are they looking for some sort of insurance coverage? What specifically are you seeking for your clients?
I guess in this stage, they will be looking more so for medical coverage. We're talking about working class people, you know, they have insurance, but would it cover, you often find people who have these debilitating illnesses run out of insurance very quickly.
And if dormant initiative goes bankrupt and out of business in 5-10 years, where does that leave with them?
You know what, we'll have to cross that bridge when we get to it. Your Honor, this case is about privilege, greed, deceit, and the petitioner's deliberate intention to produce injury or death to my clients. To my first point, Your Honors, it has already been established that my clients and others were exposed for considerably longer periods than 2 months to the EGO, a slightly radioactive component found in the others, a chemical used as soil treatment. We know that nothing good can result after years of exposure of radioactive chemicals. EGO is not a chemical element that currently appears on the periodic table, as I mentioned earlier. There's not a whole lot known about it other than it's radioactive and toxic. The unknown of this chemical element makes it just that much more dangerous because we don't completely know all of the effects that it will have on human beings who have been exposed over long periods of time.
Counsel, but at the end of the day, we have to be able to point to some bodily injury. And as of yet, your clients, they can't. I mean, there might be, but the case law is clear, not here in the state of Marshall, but persuasive case law elsewhere, that there must be a bodily injury in order to bring this claim. And that is something that we can't point to now, whether it be because we don't know the chemical or we don't have the technology to do it. The fact of the matter is that we can't point to a bodily injury to your clients, correct?
Well, then my question becomes, and I don't know that to be correct, my question then becomes, is an exposure a form of bodily injury? You know, it would be a shame that my clients would have to wait 10 to 30 years until the effects of being exposed to these chemicals begin to manifest itself, and then they have the inconvenience of having to drag themselves back down here before each of you in order to be compensated.
Oh, wouldn't it also be unfair to subject the company to force them to pay healthcare costs and coverage, which is what you said your client was seeking, for people who may even not get cancer, who this may not affect at all? Isn't it unfair to them to act so prematurely that you expose that liability?
You know what's unfair is the fact that they knew about this toxin and they still sold the land. They chose money over human lives. That's what's unfair.
And does the record reflect that factually?
Pardon me?
That the choice of money over human lives, is that in the record somewhere?
I think it's safely to be presumed that they sold land. They sold land so that my clients could pay them for that land and for them homes, but they knew what was on the land. And they knew that that the homeowners were going to be exposed to this toxin. So I think it's a fair assessment. I think it's a reasonable assessment. So I see that I'm out of time. So for these reasons, Your Honors, my clients respectfully ask this court to affirm the appellate court's decision. Thank you.
Thank you. What was that? That was awesome. Like,
She was arguing one day.
yeah,
I was like, go
you
ahead,
did.
counsel.
That was awesome.
Like, we parties, I ain't know where you headed in. Making me nervous.
If you were to do that here, you would be put on a team. I'm serious. To be put on a team here to argue, like, that was amazing. That's how you do it. Like, what I have here. I started a nice pace, allowing this one to proceed. Case law, the AIDS disease, we don't know the symptoms of that. The way you said that with Rayner, you got it off of Rayner. The endless claims question, you brought it back to the facts. In this case, like here, we know there's been radioactive chemicals here. You know, there could be endless claims, but we have to deal with the issue that's before us right now. You used the Rosalind products, assuming the mitochondrial injury. Like every question you had case law to go with it, and you made sense and logic, and your pace, your tone. I was over here smiling. I wanted to. It was nice to see.
I saw you.
It was really nice. It was nice to see. I got excited. It's such short a time that you have to prepare. We'll cross that bridge when we get there. Like we don't know what's gonna happen.
I'll be here next year as a rising one out.
Oh, really?
God's will, yes.
I'm gonna keep my eye on you. They chose greed and deceit over human lives. You know, usually in moot court it's harder to have themes, but you made it work. Like you had a theme up there, and you, at the end of the day, I always say this: judges are humans, and you say something like that, it made me make them feel like the bad guy, and you paint them out like the victim. So I really like that. Bodily injury, I asked you, and you were like, well, it's safe to say, you know, there's chemicals there. They knew. It's reasonable to assume that they knew they were, you know, putting chemicals in this land. Well, you had 1 minute left. You said I'm out of time. You had a minute left. So, nice job.
I agree. And I knew you'd be well prepared. I knew you were well prepared. I had down, you don't need to read all the names of the respondents at the beginning. I don't know if the others, if in your practice, if you think that's more effective, but that's minor. I thought it was good that you referred to the Rainier case right up front, and you made a good reference to the Rosalind case. After you answered a question, it's not necessary to say, may I go on? You can just go on. And there also, just towards the end, when you said, my question is, I might phrase it, you know, according to some case authority or something, rather than make it personal, but you did, you know, you did a very good job. And I would give you more compliments, but you're already overloaded, so I don't disagree.
From the moment you started, I was hooked. I mean, you were compassionate, you were driven about your cause, but you weren't overly so in a very dramatic kind of way. I mean, look, in this case, yeah, this is something you kind of get excited for if you're representing them. I mean, there's this radioactive substance in the ground and they're refusing to pay for the medical. It's just unfair. So I think you showed a great amount of just passion with it, and that's persuasive in itself because even though understandably it's not a real case, you made me feel like you truly believe in this cause, and if the attorney who's arguing kind of wavers in it and his belief, then why should I believe it? But with you, I never doubt for a second that you truly were right and that you knew what you're talking about, and you quoted that case to me, which was a perfect answer. You knew what you're talking about with that. You framed the issue perfectly. I might have asked you a little bit of an unfair question when I asked what you were requesting for the plaintiffs and all that, but that's kind of an expected question. In this case, it's very hard to figure out what you want. I mean, you don't know really realistically if they're going to get it, but they might, and it could cost them anywhere from no money to hundreds of thousands of dollars. So I guess what I would say for that is kind of have an idea of what you want, maybe more specificity. You end up with a good one, but just kind of be prepared for that question in case it comes. But otherwise, yeah, I mean, you knew your stuff. It was good. It was great.
Travis Sumpters?
Yes.
Okay. I'll give you all the good stuff and they can give you the bad stuff.